So today in this video, we have Erik Hartstrom, who is an estate attorney. Thank you for your time today.
Absolutely. Glad to be here.
And Erik, I know that you specialize in trust, probate, special trust, and conservatorship.
Right.
Can you please give us an introduction of yourself and explain the roles of a estate attorney and how it relates to home ownership?
Sure. So first of all, thank you for having me this morning. And I've been practicing in the California area for about 20 years now. Doesn't seem like it's been that long. And I started actually in family law before moving to estate planning. So I got to see a lot of just families going through tough times, and then moved into the estate planning world, which is families taking care of each other. And I just love it. I love families who want to make sure that they're taken care of, that their kids are taken care of, that everything's squared away. And I just get to help them every day of the week. So it's been a fun practice, and I look forward to sharing with you some of the things we're going to talk about today.
Yeah, and I'd love to talk to you about family law, but we'll save that for another day.
Definitely.
So can you please explain your role as an estate planner?
Sure. So what we're doing is California has some default rules that apply for everybody. The trouble with those default rules is that the process that is there by default is very cumbersome, which translates to being very slow and expensive. And so unless you take some proactive steps to protect yourself, protect your family, the default process is not going to be pleasant for you or your family. It's going to involve extra expense, and could it lead to some surprising results that you didn't intend or your family had never expected. And that's where a lot of frustration and a lot of broken family relationships come from. And so as the estate planning attorney, my job is to understand what your goals are and help you spell those out in a clear, concise way so that your family can avoid a lot of frustration and a lot of unnecessary expense.
Mm-hmm. And as a quick preview or overview, what's kind of the default situation that society puts on when it comes to estate planning without consultation?
Sure. So the two big things are conservatorship, which is when somebody becomes incapacitated, and we have to step in and appoint someone to manage financial decisions, medical decisions on your behalf. And the other one is probate. And so most people have heard of both of those things, but they just never really think about either of them applying to yourself. It's just kind of one of those things of we just always imagine ourselves continuing forever, and we're always going to be fine until we're not. And so kind of breaking out of that expectation and saying, hey, there's things that are out there that can happen. I put my seatbelt on when I step into my car. This is just one of those legal seatbelt things that I just have to do as an adult to make sure that I'm protected.
Mm-hmm. Hope for the worst, plan for the best, right?
Exactly.
And what are some key reasons why homeowners should consider estate planning, especially when transitioning from renting to homeownership?
Yeah, great question. So one of the main issues that a homeowner deals with is kind of the expectation of having to go through probate at that point. So in California, the default rule is if your estate's under $166,250, that's the magic number right now. And that doesn't mean money in the bank or the net equity in your property. Maybe you basically just bought it and you don't have very much equity in the property at all, depending on how you bought it. But the gross value of that property will still trigger a probate case. And so as soon as you step from that I'm renting to I'm owning a home, assuming you bought something worth more than $166,000, you're basically into a probate case. And that probate case, again, is one of those long, expensive, and complicated processes.
Mm-hmm. And how can homeowners use estate planning to protect their assets, including their new home?
Yeah, so the advantage of having a living trust in place is that you can completely avoid that probate process. Um, and in California, it also has the advantage of protecting your estate from Medi-Cal recapture. So if a spouse goes into a nursing home and Medi-Cal's providing some coverage, having the asset in the trust, at least right now, provides protection from those two things. So probate, Medi-Cal recapture. There are some potential asset protection steps that you can take, but for the normal family living trust, it doesn't provide any like asset protection the way people think of that as asset protection. But definitely what we're avoiding is all that time and expense and probate. That's usually the number one thing that we're thinking of in setting up a trust versus a will, because a will does not avoid probate at all.
And to clear definitions for anyone who might not know, 3 things. What is probate? What is a trust? And what is a will?
Okay, so what is probate? Probate is that legal process of taking the assets, the estate of a deceased person, and transferring them to the beneficiaries. So to give you a quick picture of what that looks like, we have to file a petition with the court to say, hey, this person has passed. Here's all the stuff that they owned. Here's who the executor should be. And then once we go through that entire process, then we have to ask the court to divide that estate up between the beneficiaries. So it's a lengthy process, could take over a year. It's fairly expensive. You can generally figure that it's going to be $10,000 or more for a probate case.
Mm-hmm. And what do those costs allocate towards?
So that's basically the statutory legal fees. There's some other costs associated with that as far as the court process. And then you can apply the same amount to whoever your executor is. So, a probate case technically is essentially $20,000 right off the top before we even get really started with anything.
And then what is a will? Or sorry, what is a trust?
Right. So the trust is the document that avoids that whole probate process. So the trust simply says, here's my stuff, here's who it's going to, here's who I want managing that whole process. And I'm creating it now, I'm putting my assets into it now, and that is kind of the secret sauce of how we can avoid probate. A will is a document, in contrast, that simply says all the same things. Here's what I have, here's who I want it to go to, how I want it all handled. But it only comes into effect once you pass away. And so that document, that will, has to be submitted to the probate court to be executed.
Gotcha. So it doesn't really protect you from the front part or from the front end.
Exactly. So that whole probate time and expense, the will is essentially just telling the judge what you want done in that probate case.
Mm-hmm. And on the entry level cost, how much does a trust usually cost? Because you said probate's around $20,000 off the top.
Sure. So trusts kind of vary depending on what all you're doing inside of them, but you can think usually $2,000 to $4,000 for a family revocable living trust.
Mm-hmm. Feels like an expensive upfront cost, but it's way cheaper than $20,000.
Exactly.
And what are the most common estate planning documents that homeowners should put in place before purchasing a property or while purchasing a property?
Yeah, so I really think of this as kind of an adult thing. So any adult, I think, should have 2 things in their back pocket: a healthcare directive and a power of attorney. That's kind of your incapacity protection. Once you step into that home ownership role, and anytime that you're looking at a larger estate, essentially, that's when that trust becomes super important to provide protection of that investment of your home, avoiding the probate process.
And then who do people usually elect as their power of attorney?
So power of attorney, trustee, really the idea is anyone that you trust to make financial decisions, either on your behalf or on behalf of your family. So it could be your spouse, could be your adult children, could be a trusted relative, trusted friend. Basically, you want to pick somebody who has integrity, who can communicate with your beneficiaries and keep everything moving and not get stuck in an emotional zero-sum game.
Mm-hmm. Make sure you choose someone that has your best interests at heart, right?
Absolutely.
And can you share some real life examples of how estate planning has played a crucial role in a real estate transaction?
Sure. So I'll give you two examples. One that, these are two cases that I'm working on right now. So one, there was no prior planning in place at all. So we filed for a probate case, but the house that was in the estate had been rented, and the renter moved out. And so now all of a sudden, with in a state of zero cash, while we're still waiting for the court to appoint the executor, we have a situation where we have there's equity in the home, but there's ongoing costs that have no resources to pay for them. So we had to go in on an emergency basis, ask the court for permission to sell the house. We got that, and we're able to sell the house. So now what I have is some cash, and it's just going to be sitting in a bank account for months until the probate process concludes its scheduled notification to the creditors and debtors, and we conclude all of that. It's just going to be sitting there until we finally get permission from the court to distribute it.
What do you estimate a timeline on that one is?
Probably another year.
Oh, man.
Yeah, because we still haven't gotten an executor fully appointed.
Mm-hmm.
We got it on an emergency basis, but it's another couple months until we actually get in for the full approval, and then ultimately another roughly 6 months from that till we can actually get a distribution order.
Mm-hmm. And how often does that usually happen?
That's maybe not necessarily the emergency part of it, but that is kind of a normal probate process where Sacramento County, you can figure that we're 4 to 6 months out from the time that we file something to the time that we see the judge. So if you come in and say, hey, this relative passed, let's get a probate started, just to get you appointed as executor so that you can sign off on, hey, Brandon, let's get this property sold, is 4 to 6 months out. Okay. And then once we get that property listed and sold, the cash again is just going to be sitting there until the statutory time frame runs out for the creditors to submit any claims against the estate. And then, there's other things before we can conclude and ask the court to distribute it. And then once we are ready to ask the court to distribute the estate, again, we file that, and then 4 to 6 months later, we can see the judge.
Yeah, no, that's
to
crazy.
get the order. So that it's when we're talking about it takes a long time. It takes a long time.
Oh yeah. Sorry. And then what was the second scenario?
So the positive scenario was we got called in. This lady had a major medical condition, and so we were able to get her estate plan done. And she was in the middle of trying to sell her property. She had it listed and hadn't sold yet. So we knew because of the medical condition, depending on how fast the sale may or may not happen, she may not live through the whole process. So we were able to come in, get a trust done, get it recorded. And ultimately she did pass before the property sold. So now the trustee is managing the property. The realtor basically just made a few changes on the listing. It's still a normal listing. And the trustee was able to sell the property. Didn't need to go to court for anything. So essentially there was zero wait time. And so that's the key difference between managing it under a trust, zero drama, versus under probate, a lot of lawyer time, a lot of expense, and a lot of frustration there.
Now, you were able to do a trust in a very short time period, I'm assuming, because it was within a listing time period.
Right.
How long does a trust usually take?
So
To fulfill, sorry.
Sure. My typical process for the time that you come in to the time that we're signing documents is usually around 3 to 4 weeks.
Okay, cool.
So just, give me time to do the work on my side of things. But, in an emergency basis, we can move much, much faster, obviously.
Mm-hmm. Just as long as the situation calls for it and things need to be pushed as fast.
Right.
How does home ownership impact the distribution of assets in an estate? And what steps should a buyer take to ensure their wishes are met?
Yeah, so this question kind of reminded me of a client that I worked with that had 4 kids, and she had 4 investment properties, basically, or I should say a home and 3 investment properties. So a house for each kid was what she came into my office with. This is the picture in her mind. A house for you, a house for you, a house for you, a house for you. So as a realtor, let's just say we've got 4 different properties around town. Maybe they were bought for roughly the same amount. Would you expect them to still retain the same exact value?
No, definitely not. And that was going to be my question.
Exactly. So when you're thinking about, here's everything that goes to, my kids, my advice to clients is usually think in percentages, not specific assets. There's time for thinking, this is a particular asset, has this story, this reason that it needs to go to this particular individual. Like, I know this house is in my name, but all I was doing was helping my child buy the property. They put in the down payment. They've been making the mortgage. That house is going to that kid. Makes sense. And there's other, individual stories. So really, there's a ton of detail that goes into why we do what we do inside any particular trust. But just thinking, I've got 4 houses and 4 kids, just made me laugh.
How did that get resolved?
So, we talked about it, and so ultimately we did the percentages and kind of left it as more of a wish, a note for the family, so they kind of knew, okay, we're going to do this, but we'll still equalize it. So, at the end of the day, I think one of the kids was ready to just liquidate the one particular investment because of where that property was, and they were able to kind of use that to balance out the estate.
Man, no, that's smart thinking, because you definitely don't want one of them to be left with the $400,000 house and the other 3 with $1 million plus.
Right.
And are there specific considerations for homeowners who want to pass their property onto heirs or beneficiaries?
Yeah, so there's a lot of what I would call shortcuts in estate planning. And they all have some very specific pitfalls. So, obviously, as a trust attorney, kind of the expectation is I'm going to sell you the trust as the best answer. And it's true, I think it's the best answer. But if I didn't think it was the best answer, then I'd go find something else to do. I mean, there's a million things I can do as an attorney. I think this practice, provides a ton of value for clients, and that's why I do it. And part of the, some of the shortcuts that people come up with are, I'm just going to add my child to the property.
Mm-hmm.
Okay, and I've come across that many, many times. The challenge with that shortcut is it does a couple of specific things. So a couple of pitfalls are, number one, you've just inherited all your kids' financial problems. Mm-hmm. So any creditor of theirs is now a creditor that can attach your house. Mm-hmm. Okay. And if you go to refinance, if you go to do anything, then
you need that signature.
Right? I had a gentleman call me. He's in a relationship, added that individual to title on his house, and now he's like, well, I just need to get her off. Well, that's fine. Have her sign something. Good luck with that.
Yeah.
It's a legal document. You can't just add somebody, make that, essentially it's a giant gift. And so there's tax consequences. One of the ones that can catch people by surprise is that for capital gains, if you inherit the property, you get a step up in basis. If you gift your child the property, they don't get any step up in basis. So they're going to be left with essentially an investment property that has a basis from when you bought it in the 80s versus right now. And so it's a big challenge for kids trying to sell the property now because the basis is staying the same.
Yeah.
They just get added onto the property.
Gotcha.
So it may seem like, I'm saving myself some legal fees and time now, but ultimately you're going to pay more in taxes and potential problems down the road.
Most shortcuts have pitfalls when it comes to the legal discretions.
Yeah, absolutely.
And what role does estate planning play in minimizing estate taxes and ensuring smooth property transition to heirs?
Yeah, so we kind of talked about, probate versus will and trust. For estate taxes, one of the big things to keep in mind is estate taxes apply to really a small percentage of people. Essentially, we don't even start thinking about estate tax planning unless your estate's larger than $6 million. That's just kind of my individual rule of thumb. The individual tax exemption rate is over that right now. In a couple of years, it's set to drop back down to around the $6 million mark, and it's adjusted for inflation. So from a long-term perspective, on an individual basis, that's just kind of the target that we're using as, okay, if we're approaching that, then we need to start looking at what steps can we do to make sense. Because there are trust planning techniques that are available to avoid estate taxes.
Gotcha.
One of the other interesting taxes that is out there, we talked about capital gains quickly, was charitable remainder trusts are an interesting tool that's out there for clients that have highly appreciated property. So maybe they're not a multimillionaire, but they've got this highly appreciated asset with some major capital gains, and they're just kind of worried about
what can
taking
happen.
that capital gains tax hit, but they'd really like to liquidate the property, but they got this capital gains tax, so they're not sure what to do. So it'd be worth talking about a charitable remainder trust in that instance.
How can renters transitioning from home ownership incorporate their new property into their estate planning effectively?
Yeah, so one of the nice things about trusts is they're designed as containers. So as you change assets throughout your life, you're not amending your trust in any way. You're just taking assets out, you're putting assets in. So let's just say you have a trust, you're buying a new home. All you need to do is give your trust paperwork to the title company, and they'll take care of you. Again, depending on the lender, some lenders don't want you to put if you're borrowing money, some lenders don't want you to put the property directly into the trust, in which case you just see me afterwards and we'll get that property into your trust for you.
Can you discuss the importance of choosing an executor or trustee and how it relates to the real estate asset?
Yeah, so like any asset or investment, the trustee that you pick, you want to make sure that it's somebody that has integrity, that you trust, and that can communicate well with your beneficiaries. They don't have to be the most amazing financial investor person in the world if they know enough to go talk to the best financial person or talk to an excellent realtor or go seek help when they need it, right? That they don't have to be the guy with all the answers. They just have to have enough integrity to keep the ball rolling, bring in the experts when they need them.
Mm-hmm. You probably don't want to pick that cousin that likes going to Sky River.
Exactly.
And are there any legal changes or trends in estate planning that homeowners should be aware of today?
Yeah, so the kind of two big things that we watch as estate planning attorneys that kind of change over time. One has been the estate tax exemption. So, like I mentioned, right now you've got a pretty large estate tax exemption. So, for those larger estates, that makes a big difference on what we can do in planning right now. So, if you have a larger estate and have been kind of putting planning off, get it done this year. For everybody else, it's just a general get it done. And the other thing that has kind of changed for families and just not really directly involved with estate planning, but Prop 19 and how your properties go to your children. So just knowing that any investment properties that you have, or if you're leaving a home to a child and they're going to keep it as a rental, just being aware that it's going to get reassessed when they inherit the property.
Gotcha. Prop 19, which was in place 2020, correct?
Right. So I guess the advantage for you as a homeowner is once you reach that age, I think it's age 60, you can take your property tax exemption anywhere in the state and keep it with you, which you couldn't do before Prop 19.
Mm-hmm. Super beneficial, because I have clients that they built a home for the ground up in San Bernardino area.
Oh, yeah.
Probably costs about $1 million now, but they bought the land for super cheap. Hasn't gotten reassessed yet. That means that they can bring that tax exemption up north, right? Or not tax exemption, but property tax.
Property tax, yeah. As long as they meet the age requirement, they can take that property tax exemption with them. Absolutely.
Nice.
Yeah.
And how can homeowners work effectively with an estate planning attorney to create a comprehensive estate plan that aligns with their real estate goals?
Yeah. So one of the things I mentioned is it's easy to add stuff to your trust. You just give your trust paperwork to the escrow officer when you're or your real estate agent when you're getting your purchasing that new property, and then just keep it in mind once you create that trust. Family life events are really kind of the main thing that you need to come back and see your trust attorney. So if there's a remarriage, maybe there's some family changes, particularly if you name somebody as a trustee and now that relationship's different, or maybe you had younger kids and now they're older and it's time to bring them in into the decision-making process. So these trust documents are super important, but don't think of them as completely static. You need to look at them. I kind of jokingly say every decade. It's kind of a long enough time for life changes to be super noticeable from the time that you planned your documents back then to now.
And are there any potential challenges or disputes related to estate planning and home ownership, and how can they be prevented or resolved?
One of the key things that I think leads to, let me put it this way. One of the areas that lends itself to potential litigation is blended families. They just run a higher risk than other families of having potential litigation in the way that they plan or most likely don't plan. And in those particular situations, those particular families, it's very easy to come up with a result that no one expected just by virtue of how the law is written. And so for blended families, it's extra important to get in, talk to a good estate planning attorney, make sure they understand, what the default rules would be if they didn't have any planning in place, and what exactly they want to have done with their estate and with their assets, and making sure their spouse is taken care of, making sure their kids are taken care of, making sure the other spouse's kids are handled appropriately. And there's just a number of issues that you need to be proactive about. Maybe it's some difficult conversations, but better a difficult conversation than an unintended consequence when somebody passes.
Mm-hmm. Especially when, these are your assets and you most likely want to have a choice in everything.
Absolutely. Yeah. So I was just talking to a family this morning. He's got his kids and his assets. She's got her kids and her assets, and they have assets together. And so how does that all work? And So what do we do with that? We can be very specific inside an estate plan and make it crystal clear. At the end of the conversation, they were, totally, they knew what was going to happen. Their family was going to be taken care of. It was one of those situations where, it could be, a giant blow up situation. But everybody was happy. Everybody was clear about what they were doing. And, you can just see, tons of money in attorney's fees in fighting families just off the table because they were being proactive.
And finally, what are some practical tips and best practices for homeowners to ensure their estate plans are up to date and well suited for their real estate assets?
Yeah, so just keeping that estate up to date, like we mentioned. So, a trust is a living document in the sense of you want to make sure it reflects your current intent and reflects your current assets. So if you drafted it 10 years ago, the odds are all of your bank accounts are different. All of your, pretty much everything is changed at that point, right? So just making sure that along the way, as you change those assets, that take a second to think about, how does this go into my trust? And if you have any questions about that you've called your attorney and had that conversation. What am I supposed to do with this new account? Is this form filled out correct? What instructions do I have for the bank account? And then just making sure, I titled this asset correctly. And then for some families, they've had particular instructions about a specific asset. Now they've sold that asset and bought a new one. Well, if they've said in their trust, this particular asset goes to that individual, then they just need to update the instructions to reflect the new asset that they've got.
And last question, it's not on here.
Yeah.
Last question, because it just came to mind.
Sure.
A lot of my clients are in their 20s and early 30s.
Sure.
They are now just starting a family, and we help them buy a property.
Mm-hmm.
I let them know that, starting this mindset is definitely a good idea.
Yeah.
What are some final words that you have on that to kind of not necessarily push the agenda, but demonstrate that it is powerful?
Yeah. So one of the things that I think is super valuable for especially young families, families with younger kids, is we want to make sure we have resources available for our young kids should anything happen to us. So, we've got a house, we're getting life insurance, and we may think, I don't have a ton, so maybe I don't really need an estate plan. So we talked about the real estate aspect of it, but also, life insurance. So how do we set those beneficiaries up? We can integrate that life insurance policy within the trust to make sure that money is sitting there, it's being managed appropriately with the trustee. Maybe it's the equity out of the home, maybe it's life insurance, whatever it is, but that the money is there and being managed appropriately. Because you can say, I'm just going to let grandma and grandpa take care of it, so play out the scenario. Grandma and grandpa have the money in their estate, and maybe they're using it appropriately for your kids, but then they pass. And so now grandma and grandpa's estate, which consists of partly your money that you left for your kids because you named them as beneficiaries, or maybe you didn't do anything. And so now grandma and grandpa and their estate is being divided between everyone else. Yeah. So you got to think one or two steps ahead as an estate planning attorney, and don't just leave it where it is.
And that concludes it.
Yeah.
Thank you so much for your time.
Absolutely. Thanks for having me, Brandon.
Any other things that you wanted to talk about?
Oh, man. I think that was good. Yeah.
Yeah. No, that's powerful.
Yeah.
Cool. I think we covered a lot of ground in 36 minutes.